Alvin Butler will have the opportunity to present all of his arguments, represented by counsel, present evidence and witnesses on his behalf, and cross-examine any of the city's witnesses. The city shall also be represented by counsel and shall bear the burden of proving the grounds for denying the license. This hearing shall take no longer than 2 days unless extended at the request of Alvin Butler to meet the requirements of due process and proper administration of justice.
There's one narrow issue, and that is whether the building commissioner properly issued a letter of intent to deny a license under ordinance number 1418-2012. That ordinance was passed on September 17th, 2012. An application to operate a sexually oriented business to have a license to do so at 310 West Jacob Avenue was filed on November 7th, 2012. Pursuant to the ordinance on November 26, 2012, Mr. Twitchell, the building commissioner, issued his letter of intent to deny based on the grounds that the ordinance in section 4A3 prohibits the issuance of a license, actually 4A4 prohibits the issuance of a license to a sexually oriented business that is not in compliance with the location requirements of that ordinance. It's limited to that ordinance and the grounds, therefore. Section 19A specifically provides that no sexually oriented business may be operated within 750 feet of a parcel containing a residence. That was the basis set forth in the November 26, 2012 letter of intent to deny the license application. On December 5th, 2012, Mr. Butler submitted a request for a hearing on his sexually oriented business license application. And that is the narrow issue. Prior to the beginning of this hearing, the attorneys for the parties entered into various stipulations as to facts to be stipulated to, evidence and exhibits, identified witnesses or potential witnesses, and that was signed by Mr. Schaub on February the 8th, 2013. It was signed on that the same date in the hearing officer's presence by Mrs. Siebert on behalf of Alvin J. Butler. And we received yesterday, while I was en route to travel here to Indiana, apparently Ms. Siebert filed an attempt to withdraw the stipulation as to the stipulated fact in that signed document. And that stipulation was that the parcel at 310 West Jacob Avenue in Angola is within 750 feet of at least one parcel that contains a residence. That was stipulated to. I believe that once you've entered the stipulation, you're not allowed to withdraw the stipulation. If there is an exception to that rule, it would have to be for good cause. To date, there's been no cause or argument made as to why that stipulation should be withdrawn or a party should be allowed to get out of that stipulation. That's especially true when the attempted withdrawal happens one day before the hearing, and the parties previous to that have prepared their cases and lined up witnesses according to the agreement made by the parties, and that prejudices the city to try to do a last-minute withdrawal. So in that level, it might help if Your Honor addresses that issue because it may affect the scope of the evidence that the city puts on if that stipulation is going to stay in the record or if Ms. Siebert is going to be allowed to withdraw it.
With respect to, just to quickly address the request to withdraw the stipulations, the fact the city has the burden to prove whether or not there is a residence or residences within 750 feet. We have filed our notice of intent to require them to prove that. We are not calling any additional witnesses. We're not introducing any additional exhibits for that reason. We're just requesting that the city actually prove and bear their burden of making out whether or not the denial is proper or improper. The only other specific issue I have to address is the constitutional question that could be raised as to whether or not this ordinance is proper, whether it's constitutional. Under law is not a resolution that can be made before an administrative body. The question of whether or not an ordinance is constitutional, in fact, is for a court of jurisdiction, an actual court, to decide. The site for that is Indiana Declaratory Judgment Act, It's under IC 34-14-1-1. There's also progeny case law that follows that specifically. And for this reason, we are not placing any of the constitutional challenges before the hearing today. To the extent that any kind of constitutional challenge could or would be made now or in the future, we expressly reserve our right to make those constitutional challenges in federal court or in the courts that we deem proper under the case law of England versus Louisiana State Board of Medical Examiners. That site is 375 U.S. 411 in 1964. There is also a companion case in the Northern District of Indiana, and it's Palermo versus Sudnak, 382 F. Sub 1387, Northern District, 1974. So for purposes of this hearing, we're requesting that the city meet their burden so that we can determine whether or not the denial of my client's license was proper. If the court finds that it was indeed improper, then we will move forward with our case at that point in time.
I think what we'd like to do is proceed with our evidence today that we have, and if it turns out that the hearing officer in his ruling rules against us, that we, let's put it this way more narrowly, if the hearing officer rules against us simply on the grounds of insufficiency of evidence to prove the fact that it was previously stipulated to by Mr. Butler's attorney, then that would be subject to a motion for reconsideration for something else at that time. I don't think it necessarily has to be automatic that would occur.
Well, what I'm going to do is we're going to go ahead and proceed with the city's evidence. And if before you rest, I'm going to give you the opportunity for a recess or a continuance of the hearing to come back and address those issues. That is, present evidence that you thought was previously stipulated to, and you can make your decision of whether or not you want to come back or not at that point. I think it's better to do it that way than to present the evidence, have me consider everything, issue a written decision, and then to attempt a reconsideration.